Hi there, I'm Sean, and this is Sean Turns Up the Volume. Welcome back. I've got some articles I'll be linking at the bottom of this video today that have to do with something that I just came across. Somebody had posted this in a therapist group that I'm in, and I saw. So that's how I came across it. That Massachusetts recently, I think this was just in August. Well, let's see. Was this August 2024? I thought something said it was just this past August that it was signed into. Let's see. This article says August 7th, 2025. Massachusetts Governor Healy signs landmark shield law update. So I think they'd passed the law, and then they offered, and then they added updates to it. And basically from the gist that I've gotten from the shield law is they lump reproductive health care, aka abortion, and also trans ideology, gender affirming care as like extra protected sorts of health care that the state will protect, that law enforcement agencies won't be able to help, like out of state or federal agencies with investigations into like unlawful treatments being done. And let me look at I had a different article up. There's a couple. I'm going to link a couple different articles here. What else? There's a prohibition that business entities cannot disclose, in response to civil or criminal legal request, information or assistance that the business entity knows relates to a resident, healthcare provider, or business entity in the Commonwealth in connection with legally protected healthcare activity. Okay, this is what's protected under the SHIELD law. Let's see, there's exceptions. The disclosure is required under, it doesn't apply if the disclosure is required under applicable federal law or to the requester provides an attestation signed under penalty of perjury certifying that the legal request does not seek documents, information, testimony relating to an investigation into or the enforcement of another state's law that imposes civil or criminal liability for the provision or receipt of the legally protected healthcare activity that's lawful in Massachusetts. So that's saying that they won't help an out-of-state investigation. They'll maybe comply so long as it doesn't have to do with coming at the provider for what they've done. So this is obviously aimed at if there was a federal ban on abortions, if there was a federal ban on providing gender mutilation surgeries and totally inappropriate cross-sex and puberty blocking hormones, these sort of these child abuse kinds of procedures, that if it were done on a federal level, if another state had bans on these things and somebody had done maybe from within Massachusetts, out of Massachusetts to get that kind of care, that the state of Massachusetts would protect them. That it would, it says down here in this article on the Covington, InsidePrivacy.com, I'll link this, that the Attorney General may bring civil action against a covered business to compel compliance with the requirement, and any person who submits a false attestation is subject to statutory penalty up to $50,000 per violation. So if they were to lie and say that they had consent to disclose information about the care that was provided, then that business or that person could be fined by the Attorney General of Massachusetts for $50,000. If I'm, and you can correct me, read it yourself. It sounds like that if you knew another provider, if you're a business owner, or maybe you had a medical clinic or a counseling clinic, and you knew somebody provided that sort of was providing abortion, providing anything along the lines of the gender affirming care, and you disclosed that to investigators, to another state or to federal investigators, then they would try to slam you with a major $50,000 fine. So they want to compel business owners, other practitioners to not engage in disclosing information as far as investigations into that. So they want to silence people from being able to talk to investigators if this were to become criminal, because of course in the state of Massachusetts they will continue to do these kinds of things even if it was federally banned. You know that they're going to keep doing them. So they want to be able to silence people at the state level from basically being able to tattle, to tell the truth, to comply with federal investigation. And so they updated this. And the reason why I wanted to talk about this is because, well, this relates to then what's going on in the Supreme Court with them hearing this latest case. What is that case called again? Let me tell you. Case on conversion therapy. That way you can look that up. What am I doing? I can just put a link down below. What's this case called? This case was based out of Colorado. Pop-ups. I am getting blocked from... Oh, I can't look at the New York Times. I don't want to look at the New York Times anyway. Oh, USA Today tabs block-ups too. Man, if the liberal left-wing media propaganda machine wants to block all their stuff behind paywalls so that less people have access to it, fine by me. This case was called Childs versus Salazar. That's the case going on in the Supreme Court right now regarding conversion therapy bans. So obviously Massachusetts is responding with this kind of this lawfare response. Well, if federally they can't ban real treatment for all the things under the umbrella of trans issues, then they'll go the next step and go, well, the writing could be on the wall. At least they've got Trump derangement syndrome, so they figure that, well, maybe there could be a law passed on the federal level that would be banning abortions, even though Republicans have been going, no, it's a state's issue. The left knows that if they're in power, they would use the federal power to make nationwide bans on what they don't like, so they don't really get that for conservatives, if it's not something that's a constitutional federal issue, it does go down to being a state's issue. That's part of like how our nation works, how the Constitution works. They would use the power, whereas we're kicking it back to the states. So here they obviously worry that there could be a ban on gender affirming care, right? Oh no, if therapists had to actually need to explore these issues with clients and help them figure out and resolve these things without just blindly and only in one direction encouraging them to take hormones and mutilate themselves. So they are going that next step forward to add layers of protection, get in the way of what could hypothetically happen at the federal level, and go, we'll use our state power to try to interfere with federal investigations from federal laws being applied to people in Massachusetts. Now, of course, if the left is in charge, if it was their president, if it was Biden, Obama, or Kamala, if they had the majority in Congress, and then it's the conservative states bucking back, well, I mean, we know what the rhetoric of the left would be. We know what the response would be. It would be for the feds to use their big hammer and go after the states by any means necessary. So you could see this real power dynamic playing out between the federal level and states, and all of a sudden when the left doesn't have the federal power like they did, then all of a sudden they're big on state power. But when they did have federal power, they didn't like state power as far as it being conservative states. They want to put their boot down on everyone. So anyway, I just want to talk about that a bit, call that out. I'm going to add some links here. You can look it up for yourself. Thank you. This is Sean at Sean Jones with the Volume. Please like and subscribe if you like this kind of thing, and I'll see you next time.